Hi, I'm Teresa Chang.
Hi, I'm Felicia Grant Cummings.
Hi, I'm Kim Johnson with Moms Navigating Autism.
Welcome to the show. Tonight we have Marion Walsh from Littman Krooks.
Thank you so much for having me. It's such an honor to be here.
Marion works for Littman Krooks, which is a special education law firm. You're going to talk about aging out of school districts, which is an important topic because it doesn't matter where on the spectrum your child is. Once they reach a certain age, those kids are leaving the school district and moving on to college, trade school, day habs. If they're in a residential placement, they're going to go to a group home, which is, as we've had a few other people on the show, which is a whole new thing this time around because there's not enough group homes available.
Sure. So thank you so much for having me. And I'm a partner at Littman Krooks, and we have clients throughout New York State. I'm head of the special education department, but we also have an elder law department with guardianships and transition and estate planning. So right now, from a special education perspective, I'm going to talk about what parents term the cliff, either aging out of eligibility for special education or graduation. And there's two ways that students with disabilities in New York can age out or stop being eligible for education. One is graduation with a high school diploma, and that has to be a regular high school diploma, not a GED, but a diploma, not a credential, but an actual diploma from New York State, which would be, or from a private school, which would be a local diploma, Regents diploma, or a diploma from a private school, but not a credential. So that's one way. Eligibility ends upon graduation. The other way is if a student can stay in school until the question is 21 or 22, and that is the question of the day, because there's some fluctuations in the law right now. To remember, the end of the 2023 to 24 school year ends on June 30th, 2024. So if you're concerned about this year, your child aging out, you need to act right away, because once they age out, it's much harder. It's almost impossible to get eligibility back. Now, you may be able to seek compensatory services. So the question is, when does a student actually age out? So I'm going to kind of start chronologically, and I'm going to give you sort of what the law is, and then I can answer some questions. So first of all, under the Individuals with Disabilities Education Act, that's the law we term the IDEA, the law basically says that students are eligible ages 3 to 21 inclusive, which sounds like it could be up to age 22. And many states, in fact, just say students age out at 22. Now, New York has a system, and it is okay for states to develop their own systems under IDEA. New York statute or the law states that students age out at 21, but it's a little bit complicated. If they turn 21 up to June 30th, they age out in that school year, they age out June 30th. So if your child, say, turned 21 on May 30th, they would age out on June 30th under the New York state law. If they age out in the summer, so your child's birthday is July 15th, and they turn 21 that day, they would age out on August 31st, at the end of the summer extended school year program. Now, if your child's birthday is after September and they turn 21, say your child turns 21 in September 30th, they would have eligibility for the whole school year until June 30th, 2025. And that's the reason New York said it like this, is just so you wouldn't have disruption in education. So you don't say when you turn 21, that's it, you're out right now. So that was the reason for it. And that is currently what the New York State statute, the law says. Now, the New York State law is only one part of this. So just as far as legal developments, there was a case in called the AR case versus Connecticut State Board of Education. And the Second Circuit actually decided it in April 2021. And in that case, a group of parents in Connecticut with one class representative, AR, half of the class, similarly situated, claimed that Connecticut law, which was similar to New York law and said students aged out at 21, was discriminatory because Connecticut had other state programs that young people could be eligible for past 21, such as vocational education, such as training for the GED, adult education, and other things. So this first, the federal district court stated that, yes, you're right, this law is discriminatory and we have to let students stay till 22. And then the Second Circuit in April 2021 affirmed that and said, yes, for Connecticut, it is correct that is discriminatory and the law should be up to age 22 under the IDA, not 21. Now, this was the law in Connecticut, not New York, even though the Second Circuit covers New York as well, but the Second Circuit was interpreting Connecticut law. So after this decision in April 2021, there was no real definitive guidance. It took New York State Education Department 2 years, but the New York State Education Department decided in July 2023, that was last year, they stated that we've had a lot of questions about this AR case and what its impact is on New York. And they stated that, as described herein, this decision requires that public schools in New York provide special education services to resident students with disabilities until age 22 or the day before the student's 22nd birthday. So the New York State Education Department gave this formal opinion on July 6, 2023, and stated that, yes, the AR does apply. And we do think that New York law is a lot like Connecticut law because we do have programs for students or young people over age 21, such as the GED program, such as some adult education. And thus, it's very clear that based on this Second Circuit case, that New York also must find that students age out at 22 and not 21. And it can make a difference of a year. I know a year isn't always a big difference, but it can mean a very significant difference, especially in COVID times. So that was the opinion in July. Most districts were following it, even though it's the only thing about this opinion, it's only guidance from the Office of Counsel, the State Education Department. It's not definitive, it's not case law, it's not the same as a statute, a law. But most districts were, if pushed, following this, although it wasn't always clear if there's going to be state funding. And the other thing this guidance didn't do is give students a smooth transition. So if a student turned 22, say in the middle of the year in November, they would age out that day in November under this decision. And that's not really good for anybody. So districts recognized that, and they were at least most of them were giving students till the end of the year. But this is considered sort of not mandatory because it's guidance. Now, even more to complicate matters, which I wrote a blog about in April, the decision was in July and districts were kind of in flux, but a lot of them were giving this extra year till 22. Then there was a family it was actually in Katona, and that was in the opinion because it's not confidential or anything. And this family decided their son needed compensatory education, and they filed actually a state complaint with New York State Education Department. A state complaint is not a due process complaint. It's basically a complaint claiming a violation of the law, and they asked for compensatory services. And they said, that one, because of the students' need for services under COVID, they needed an extra year till 22. And also they claimed that it was discriminatory. I believe they even cited the AR case that the students should stay till 22, and they really wanted compensatory services. Now, the school district, through their attorneys, then filed a state action. So anyway, New York State gave this opinion and in their complaint and ruled that the student was entitled to be there till age 22. Now, the district, through their counsel, filed what's called an Article 78, which is a challenge to state action, and claimed that this decision from New York State Education Department was wrong because New York State law, as written in the statute, only requires students to be eligible to 21. And this state court decided that no, New York State law is not similar and that AR doesn't apply. And then until New York State really amends its statute, that law was controlling. So basically, this court, which is a New York trial court, it's not an appeals court, basically stated that the opinion was wrong and reversed it. It didn't specifically overturn the guidance, but it did certainly did not side with the guidance or with AR. And then school districts had some of them had already started to change their policies, and then a lot of them reversed and said, oh, wait, we don't have to stay till 22. No, we don't even know what's going on, so we're not going to do that. I had some situations where we would have a CSE meeting and the parents didn't know what to say in February before this decision came out, and parents didn't know what was going to happen. But certainly in the case where the district had a CSE and found an additional year, they're probably not going to reverse that. But the question was, what about students who didn't have their annual reviews yet or their exit interviews yet? What was going to happen? So the bottom line is everything right now is a little bit in flux. There is certainly a viable, strong case for students to stay in special education until 22 under the AR case and New York State guidance. However, the state court decision is really confusing school districts. But it is important to remember it's only a state trial court decision. New York State Education Department, based on my information, is appealing this, and there are a lot of good arguments for this appeal. And also, the federal law is the federal law, and under the AR case, I think most impartial hearing officers, upon seeing the evidence, or perhaps a judge, if a person went right to federal court, would have enough evidence to see that the IDA should require students to stay up to 22. So right now, if your student is aging out, I think it's important just to raise this. Some of my clients have even asked their school district boards to adopt a policy that students can stay till 22. And some have just done a lot of advocacy, and some have filed for due process. It's a time of a lot of fluctuation. It's only a year difference, but a year is a very significant difference, especially if the student and parent have not had time due to COVID, et cetera, to do transition planning or to find the next step in post-secondary education, or because of regression. We were still suffering the effects of regression from COVID. So that's where we are right now. And I can answer some questions for clarifying. I know it was a lot to go over.
It's a lot. And as a parent, that's confusing because you're saying, you're saying the law and opinion. And so for a parent that doesn't understand the law, it's confusing to me. My child, when it was his turn to age out, the school gave me fight on it, and then they were going to extend him just for the summer. This is when the bill was coming out from Parkham saying because of COVID to extend, because my son is 24 now, to extend it. And then they wanted me to sign this whole contract and said if I wanted my lawyer to look at it, but they only gave it to me right before they wanted me to sign it. So it's kind of like they set me up for failure there. And again, like you're talking about this ruling and stuff like that. So most people have had their CS meeting for the school year now. So if their child was aging out, but you said that they can't go back once they've had a meeting, correct? Is that what you were saying? Like they could.
They can go back. I was just saying if they haven't had their CSE, the district may not be willing to have it, but they can still go back and ask for it, and they can still file for due process if they don't receive it, if the district just goes ahead and exits them.
They ended up extending my son until the end of December when it went into the holidays, and he never did get an exit meeting. They never gave him one. They just wanted me to go away is what they wanted because I made a lot of noise. But we ended up finding a day hab for him anyway. I looked into having one, and that's where he is now. But it almost wasn't that because of COVID. So and a lot of people don't know what you're talking about, like the finding and stuff like that. So it's really, if we could break it into layman's terms, what they need to do if their child, say, is going to be 22 during the next school year when it's their turn for their child, I guess.
Yeah,
Because
I think if they're aging out now this school year, then people need to take immediate action if you think it's not right. And,
Okay.
probably file for due process or file something, because once a child does age out, so say your child has turned 21 in April and is aging out June 30th, it's going to be very hard to challenge that without filing immediately. You can ask the district, but they're probably not going
right,
to.
that's what I'm saying, because they most likely had their CSE meeting in April. So I mean, that was a minute, it's already passed and the school year ends in 2 weeks, so it's kind of hard.
Yeah, and they could have had their exit meeting, the document, that they're supposed to do. There are a lot of bases to challenge it. Districts, I don't think, from my perspective, districts, the exit, interview well, as you saw, or the exit document, or do the transition planning particularly well. However, can be difficult to challenge whether an IEP is appropriate based on that. There isn't a lot of case law. But if you challenge the aging out, I think you do have certainly a viable position under the case
Right.
and the New York State guidance. The New York State proposed the legislation that for COVID that the New York State legislature came out with. The problem with that is, it was discretionary. The legislator used the term may. Districts are strong.
Yeah.
May. And the initial bill did say must or shall, but then I think there was lobbying that
Yes.
that may is only
Right.
discretionary.
And then the other thing is, because Teresa knows, because she was asked to advocate. This is how I met Teresa, actually, is asking her to advocate for me.
Mm-hmm.
I went before our superintendent and said, this is not fair because of COVID. My son, like you said, compensatory going back. So that's what they called it when they finally gave it to me, compensatory services. But other families were asked to sign the same letter I was, signing their child's rights away, and they didn't understand what they were doing. I refused to sign it because I didn't agree with it. And then that's when they gave me the summer, and they said, well, what do you want us to do, Mr. Johnson? And I was like, they said we can go back to our lawyers. I said, then that's what you need to do, because I don't agree with this. Here's the letter from Congress, the letter that was written saying extended them because of COVID. And that's how I was able to get my son until December 22nd. But I think, unfortunately, some of the school districts, it comes down to the money. And if they get away with saying, hey, you have to sign this, otherwise you lose everything. Because that's what they try to do, is if you don't sign this now, your son can't even start in summer session. They tried it, and they gave it to me right before that. They tried to be slick with it. And again, I challenged it as much as I could. And on my own, I didn't go to the state ed department or anything like that. So I was able to at least get him that time, and everything fell into place, fortunately. So.
And in our school district, there aren't a lot of parents who could afford to go to a lawyer and do these things. That's
I added the money for a lawyer.
Yeah.
So, and that's how they end up getting what they want.
Right. Get away with it. They had them sign it because the families are like, oh my God, they're not going to give us the summer now. We better sign this. I challenged and pushed it for as much as I could get. When you say, because school districts offer programs like GED, you said, oh God, I can't even remember what you said, like a course, like to learn something. But what exactly is that you're mentioning, saying that they were entitled to stay longer? What kind of classes are those?
So there are, in every state, there is something called the General Equivalency Diploma, which is a high school equivalency diploma. And students take a test and take some preparation, and they earn something called the GED. So, and that can be a good thing to have, because it allows students to go to the next steps, whether it's college or certain other degree programs may require that, and it's something they can achieve, but it's not a special education program. And some districts I've seen have made the mistake of thinking that is a diploma. It's called a GED, but it's not a high school diploma. And in fact, the regulations in IDEA state specifically that a student who receives a GED, general equivalency diploma, is still entitled to special education services. And a lot of parents may not know that until 21. And the student may be ready to move on by then too. That's another issue with all this, because I have some clients who just say, my child will not be in school till 21. They just won't be available for education anymore. They just want to move on. So it can be a good thing to have. It's not an easy thing to get necessarily. It involves taking a test, and you can have accommodations, but it's really a general education test. It's not a special education program or test.
No,
So
no,
it's
no.
just
I know, I understand the GED, but I didn't know if it because there were special needs, they're entitled to longer time to get that, is what you're saying. Okay,
absolutely
that's
yes.
okay.
Yeah.
That's what I meant. And then I think you said something like, was it like a BOCES class, kind of like the skills class? Is that what you're saying? So they're entitled to, because those programs are offered and they can take it till 21. You said.
The federal court in Connecticut found that the Connecticut law was discriminatory is because Connecticut had some programs and funded by the state
Okay.
that, such as the GED program and such as adult education, that went well beyond 21, up to 22,
Okay.
and even older. So I think that was what I was saying about the GED. And the GED, anybody can get, GED later, and there is some, in New York also, there are some state-funded programs that allow students beyond 21 to take, a GED test. Yeah.
OC has some.
Well, that's what I said that's what I meant by BOCES. So something like that, if they were going for tech or cosmetology or whatever it is, because they offer it to, they could still take it up to a certain age. Is okay. So they still have programs there. Okay.
And
Right,
technically, you're still eligible, even with a GED. But a lot of people don't know that, and the districts may not tell them, and the students may think, "Oh, I've got my GED. Why would I go back to high school?" So,
Right.
but it's right in the law. It's not even questionable that does not mean loss of eligibility for special education. It's in federal regulations under IDEA.
Right.
It's a lot to process, and its transition is hard enough. And I think, and you say parents are confused, attorneys are confused, school district administrators are confused. The state is advocating, but they don't have a clear statement. So everyone is a little bit in flux, as I said, and either confused or advocating one way. I think, honestly, having a child with disabilities in this environment can cause its own trauma to parents. And there's sometimes, a trauma response, because it can be traumatic to see your child really suffering and not getting the right services and not having a future. And sometimes the parents have that response, and there's a lot of research on that. And it's important for everyone to understand that, advocates and attorneys, to have this sort of trauma-informed representation. And maybe even if it's not a formal diagnosis of PTSD, I'm not saying that. I'm just saying that there is a lot of emotional, hurt, and just a lot of, grieving, and just having a really difficult time with it. And of course, there's going to be emotional response for parents. And then it becomes even more difficult to understand these rules, which seem very arbitrary, and then the district is looking at it a completely different way. These are the rules we follow, and this is what we have to do. And we have, thousands of students to serve, and this is our lens. So there's a lot of components to this. It's
No,
I mean, during COVID, it was hard too. Like all the things that you're saying now, it was hard because when there was no day halves open, you couldn't even go in and look at them because they wouldn't even let you in the buildings to find them. So now you're saying, what am I going to do with my child? Is he going to just stay home and look at the walls because now he's aged out and they're not extending him due to COVID? And even though a lot of these schools got funding through the grants when it was COVID, they didn't want to spend the money in special education. Their grant, they wanted to use it for other things, some of these school districts. So it was very challenging, very stressful.
It is challenging.
No. Yeah. A lot of people didn't know. They didn't even know about the funding and the grants. And, it just made everything worse because you were having parents who were having their CSC meetings via Zoom. They were having their evaluations via Zoom. And it just made everything confusing and worse.
Oh, yes. And for the students, too. The students, probably the hardest, because at that age, you need to be around people, and especially students with autism, you need to be, around people, learning these communication skills, learning, the regulation skills. And there's so much more dysregulation, more behaviors. And it makes it, and then there's, of course, on top of it, staff left, there's often schools that are understaffed. So there's a kind of a lot still going on. And even though COVID, it started in March 2020, we're still feeling the effects, put it that way.
Yes, exactly.
There is a lot to think about with transition. It takes a lot of time to plan, and unfortunately, districts don't always do enough. And, OPWD has been, that's the Office for People with Developmental Disabilities, has been in a lot of crisis, mainly because they can't find workers and they don't pay, quite frankly, they don't pay enough for a lot of the workers. And so it's very hard to find people and hard to get, the services that students should be able to access.
At the beginning, everybody was thinking it was COVID and, people fearing going back to work and stuff. But even now, they can't find workers.
No, they
They're
can't.
advocating now at the Day Hab. They take individuals that actually go to the program that can advocate for the program for DSP workers and stuff. And they go to Albany and, they're there saying, hey, our DSP workers need more money. They deserve more money. And again, the individuals who get the services from them are able to advocate for themselves and the people that provide services to them. So,
yeah.
Yeah.
And I think, adults never really accounted for that for students. I think a lot of adults, if you're established, you have a job you can do remotely and you have a home, or you're not even a home, but you have a stable environment, it's not going to affect you as much. But nobody really understood the impact on children and adolescents and young adults with this isolation, because it was really, there was just so much loss. And I mean, every student, especially students with disabilities, though, and then the mental health crisis followed that, which is still, occurring, and it's and was in place before that, unfortunately. So, but no one really understood this, and no one said, "Oh, yes, everyone should have an extra year." I mean, the state tried; they said students may, but I think every student, really, there should be this recognition. It should have been, because first of all, the amount of students with special needs and disabilities grew because of the lack of instruction and learning and mental health concerns that developed. And then there was
another one,
higher needs, and then less staff. It became really an untenable situation for everybody, unfortunately.
A lot of children, they didn't know what was going on. If you were on the spectrum, you really, it was worse. It big trend. They do not go through transition very well.
Yeah, exactly. Yeah. And even, whether higher functioning, depending on the level of functioning, it didn't matter, for everybody. I mean, especially students who couldn't access the remote learning, but for everybody it impacted, absolutely. Students with autism especially. So we're all still navigating that, unfortunately.
Yeah. But okay, so the way it is right now is they are waiting. They're waiting to see what is the outcome.
Yeah, bottom line is, quite honestly, I think if as a parent you really push this, if you're informed on this, if you understand the AR case, if you have a copy of the New York guidance, you can really push this to have eligibility till 22. And you don't even, if you can do it yourself, you can do it with, or you can find an advocate or an attorney. If you have to file something, you may need an attorney if you need to, if you're aging out right away. But I think there is enough of an argument that you can definitely push this. And I do think, it's only a matter of time in New York for this to change, just like a lot of things. But it's for these students right now who are aging out, say this year, it's really it's a crisis, so it isn't. I mean, I know you're probably talking about a small number right now who are turning 21, who the parents aren't ready for them to age out and they don't have a plan. But I think for those students, absolutely, they should really push this. So, it's not that
with the state ed department, is that where they file the complaint with the state ed department? Is that where the complaint gets filed?
Well, you can file either the state ed department, or you can file for due process with the hearing officer, or you could probably go right to federal court to seek an injunction. That might take an attorney to do that. I've only done that in one case, and you have to then show it's not a pendency when a student is turning 21. Pendency means stay put. So you're not claiming stay put. You're claiming to age the student out is really going to cause reparable harm, and that you have a likely success to win this case, success on the merits, it's called. But that you would need an attorney for. So you either file in federal court, or you file for due process, or you can keep advocating. But once the student ages out, though, the advocacy part is going to be pretty much done. You can file for compensatory, but it's a weaker argument once they actually age out.
Yeah, even then with the state ed, it was hard to do because, again, that law that they were trying to pass is the may and shall, and you just kind of get bounced back and forth, back and forth. So I was getting nowhere because I was like calling them on a regular. There was somebody I was dealing with that was in charge of this area, and
And remember, yeah. So to answer your question, Teresa, I can't say what the law is because I will have one perspective on the law, and you talk to another attorney, they would have a different perspective. And that's sort of what you learn in law school, is not just what the law is, but how to advocate for what you think it should be. There are black letter statutes, which is what the New York state law says right now, but the IDA does take precedence over that in a lot of ways. So it's really a perfect storm of sort of the statute, like you said, the statute, the guidance, and the federal case law and the IDA. It's all how you interpret it. And I think that this will change in New York. I just think for students right now, it's really that there's this unfortunate confusion.
Well, now that 1 in 36 people are being born with autism, I was, which went down from last year from 1 in 52, something's got to be done. So,
yeah, and a lot of students with autism will graduate with a diploma, a regular diploma. And, we also tell parents that if you don't think your child is ready in 4 years, they don't have to graduate. If you can, but you have to work on those credits and not maybe have your child take certain credits at a certain time, or not take those exemptions from COVID. If you want your child to have more time and not graduate, that's a whole nother issue.
Right.
Right. A lot of districts didn't follow the rules that with these Regents exemptions, they were supposed to give parents a chance to opt out and notify them. And they didn't always do that. So when it was a lot easier for students to graduate with the Regents diploma during COVID times with these exemptions. But sometimes that graduation wasn't best for the student that early because, maybe they were just 18 and they didn't have an option. They weren't ready for college and or anything, and that's another issue too. And every parent and student, they have to weigh that because, you have to weigh the student has worked really hard and they want their diploma and they want to move on with their class. And they thought it's going to be 4 years. But remember, it's not always 4 years. Students can stay until 21, especially. And, it doesn't have to be 21. It could be 19. But, they could have this at extra time. But the districts won't just agree sort of, okay, sure, we won't have them graduate. You have to kind of look at the credits and really be aggressive on it, and the student has to be on board too. You're right. Absolutely.
Right. They did not say you can opt out. Had they said that, I would have really thought about that. But they didn't say that, and there were so many things that were changing, and I wasn't sure. But then again, I looked at him and I talked to him, and he said, "No, I'm ready to go." So he was ready to go. So out he went.
Yeah. No, that makes a lot of sense. And there's a lot there. Theoretically, there should be more. More to access after and more support, but there just isn't enough right now.
Right. And let me ask you one last thing. So if you were to give somebody some advice that, let's just say, couldn't afford a lawyer, what advice would you give them as far as keeping their child in, or if they need something, or,
I think, there are so many students with so many different needs. So the first thing is to know your child, know their needs, have a good IEP, have very good evaluations. That's the first step. And then you have to work with really your child to become, to the extent they're able to be a self-advocate, to become an adult. And parents have to step back a little bit, unless you're going to be in a guardianship position. That's different. But you have to navigate this with your child in mind, what they need. And to the extent you can, of course, you work with your school district on when the appropriate time is, whether to get a diploma or to exit. But you have to keep in mind that, as parents all know, that after either graduation or aging out, there is this cliff. And so you should be advocating and looking at these rules and laws to the extent you're able to, and be able to articulate why your student may need more time, or does need more time, or is entitled to more time. And but you, like you said, I think, Teresa, you have to have your the young adult on board as well, because if they're, especially if they're turning 18, they are adults, and make sure that the person is a partner with their partners with you. But the best thing is there's a lot of resources available from both New York State and from the IDA, and you can do a lot of research on your own on what your child's rights are and needs are, and work with the school district if you can't afford an attorney. But remember, the school district is going to have a very different lens than you do, because they have a different aim to educate, a lot of students. They are graduating them as a success, having them exit as a success, because they have to, maximize their resources. That's not even and they view it as, we have to serve students in a way that's appropriate, not what's maximizing their potential. That's how they're going to view it. So I know that's a lot, but the bottom line is be an advocate and help your child be an advocate and be informed, I think.
Right. I want to thank Marion Walsh for joining us tonight. And we want to remind everybody that we are mothers. We're not professionals. We're sharing our experiences so that we can help you with your autism child.
We'd like to thank Altis for allowing us to use this platform to share our opinions as mothers. Thank you.
Watch us on all social media. Don't forget to follow, like, and subscribe.
And please like our videos. Let's get that algorithm moving our videos out.